Thank you. And I'll follow up with Mr. Johnson. Do you envision any kind of a test for the question of whether a DJ would take precedent? For example, would there have to be a relationship between the retailer in which you have a responsibility to indemnify him? And could that be a test if we were to enact it in law that could codify that?
I do think we would have to look closely as we move forward in developing the legislation, because there are a variety of relationships between suppliers and their customers, and there may, as you point out, be indemnities. There may be UCC implied indemnities, and there may be some situations where the components have been supplied pursuant to the specifications of the customer where it would not be appropriate.
Well, and I want to thank you for that answer, because that begs the point for us in legislation. I wouldn't want to see an automatic stay based on a manufacturer's DJ that, in fact, there could be a material difference in the two cases, and I wouldn't, if I were a retailer or someone else in the supply chain, I wouldn't want to be prejudiced by a case being argued somewhere else. On the other hand, you don't want to be prejudiced by it. But I do think you're onto something very important. As a manufacturer, they never shopped my venue. As a patent holder, I have to be honest, when I found myself with Chrysler in a DJ in Detroit, I was not happy. So I'm well aware of that, that why each of us would look at that. Let me go back to Mr. Chandler. Currently, we do have this dilemma that the ITC is where you go for an exclusion/injunction, and you go to district court for damages, and you use one against another. It's an oddity of Congress that we have jurisdiction over one part, another committee has primary jurisdiction over another. The two questions I have for you is, should we as a Congress actively take on to resolve this so that never again could somebody essentially shop both to the detriment of, to be honest, cost to the government and for a resolution not envisioned post-eBay?
Well, certainly there's been a trend in the last 5 years since the eBay decision to a very significant increase in the caseload at the ITC, both in terms of number of cases and number of defendants involving non-practicing patent entities.
But and I don't want to limit it to non-practicing. If you take the Qualcomm Broadcom suit, you had two large, and there were others. There's Kodak. There's others. You have large domestic entities in which they clearly both are domestic, and importation is simply a matter of a portion of the supply chain in America today, including for your company. Those are really the cases where I want to know, because we can talk about trolls, we can talk about people who don't manufacture. The ITC requires there be a domestic entity in order to get standing, but let's assume that you're talking about two S&P 500 companies, substantial assets, more than enough to pay any damages, and yet one of them goes to the ITC in order to essentially twist the knife and get a settlement.
Well,
it could be your company doing it to somebody else on occasions.
The ITC has a specific mandate to move quickly to stop foreign knockoffs from coming in. Now, some parts of the supply chain, as you've alluded to, there simply are no domestic sources of components, and the fact that a very small component of a essentially domestic product comes from abroad and is alleged to infringe can subject you to the ITC. I wouldn't say that the ITC's reason for existence is obsolete, and certainly...
No, and I'm not suggesting that. My time is very limited. What I am suggesting is that currently, in some of the cases I mentioned, the ITC told us they were without power to do anything other than to use the sledgehammer that they were given, and we in the Congress have the ability to give them an additional tool. For example, the ITC finding that there are substantial domestic assets sufficient to pay any damages could choose to stay their case and recognize that their need is only when, if you will, there's an import situation in which money is not going to be paid because there's not a substantial input. And to be honest, the Open Act, something that I sponsored in the last Congress and will redrop this Congress, envisions that in the case of intellectual property, classic movies, music, that the ITC may have a greater role because it is by definition coming from entities that you can't touch other than through exclusion.
I agree with you completely that a rationalization of the dual jurisdiction and duplicative litigation would make an awful lot of sense. There's no reason that these cases need to be carried out in two different fora simultaneously.
Thank you, Mr. Chairman.